Good afternoon and welcome to the Institut Européen. It is a pleasure for me to open this today's conference as part of the Horizon Red Spinel, Europe Red Spinel project. Now, for our invited speakers, allow me to remind that Red Spinel is a research project founded by the European Union, Horizon Europe project, which brings together 7 academic partners and non-academic partners, all represented here in this audience. Red Spinel stands for responding to emerging dissensus, supranational instruments and norms of European liberal democracy. And together, academic and non-academic partners in this project, we try to understand what we call a central phenomenon in our democracies, which is dissensus over liberal democracy, meaning rule of law, fundamental rights, and other core principles of liberal democracy. Well, what do we mean by dissensus? Perhaps this is the question you are asking yourself. Well, dissensus is a phenomenon that we are attempting to conceptualize in this project, and we understand dissensus, by we, I mean myself and my colleague Natalie Brack, as the expression of conflicts that oppose different types of actors, political, legal, social actors, in different institutional arenas, targeting liberal democracy and core principles of liberal democracy, with the aim to replace, restore, or maintain liberal democracy. So we also argue in this project that dissensus over liberal democracy is triggered not only by external actors, external competition, but also within the European Union by internal contestation. So basically, in 2 words, the aim of the project is to understand the nature of dissensus, to map the actors of dissensus, and also very importantly is to analyze the impact of dissensus on EU's policies and also EU's capacity to act internally within the EU, but also externally in the EU's external policies. So we do this. This is not an abstract project. This is a very concrete project, although dissensus is a theoretical reflection and abstract reflection. So we try to understand and shed light on dissensus on specific areas, which are the following: one, rule of law instruments. So what is this is one of our work packages. Dissensus in the neighborhood. This is another work package. Protection of fundamental rights in the European Union. This is another work package. And then economic governance. So dissensus in different areas. This is how we design collectively this project. Now, our project is at the halfway stage, so this is the beginning of the 2nd year. And for this conference that we entitled The End of the Permissive Consensus and the EU's Response to Dissensus over Liberal Democracy, we wanted to give the floor to institutional actors and to hear also perspectives from inside the institutions about the nature of dissensus. You will tell us probably that we are wrong and there is no dissensus. We are very interested and looking forward to hear your views on that. So we proposed a couple of questions, which are also the questions at the core of our research project. And the questions are: how are EU institutions dealing with growing dissensus over liberal democracy? What forms does it take in different institutional arenas? How have EU institutional actors responded to increased dissensus? And what are the implications? What are the implications for the EU, for the institutions? This is a broader question for the EU's capacity to act, for its policies and instruments. Since our project is about the European Union and we consider that what happens inside the EU institutions is very, very important, for this conference and for this event, we invited 5 guest speakers, and I will start from my left, which is also, I introduce first Pervenche Berès, former member of the European Parliament, Social Democrat, member of the Social Democrat group, also a member of the European Parliament, so as I said, from 1994 to 2019. Very recently, she was coordinator of the European Parliament's Committee on Economic and Monetary Affairs during the Eurozone crisis, and also after chair of that. And then vice chairwoman of the European Parliament delegation to the convention responsible for drafting the Charter of Fundamental Rights of the European Union, and a member of the European Convention, substitute member of the European Convention, responsible for the European Constitution or the European Convention, and also vice chairwoman of the Socialist Group from 1997 to 2004. Next to Pervenche Perez, we have Julio Baquero Cruz, who is a colleague of us here at the Institute, professor at PU Law, and also member of the legal service of the Commission. With Julio Baquero Cruz, we had a lot of discussions about the financial regulation, the rule of law conditionality, and many other instruments which are at the core of our Red Spinel project. Next to Julio Baquero Cruz, another colleague, professor of EU law, Martin Martinez Navarro, referendaire at the Court of Justice of the European Union, and referendaire, yes, as I said, and also a friend of the Institute and of our Red Spinel project. My right now, so Jakob Heuvar, permanent member of the COSAC Secretariat. COSAC is the Conference of Parliamentary Committees for European Union, which brings together the EU Affairs Committee of National Parliaments, a very active organization. Now, since I attended one of the meetings, I can tell, but this is a very interesting structure, very interesting also for the discussions in our project. Thank you very much for being with us. And last but not least, Marta Arpio, who is representing today the Council of the EU. Marta Arpio is director for follow-up to the conference on the future of Europe, with experience in the Council, the Secretariat General of the Council. From 1987 to 2007, Marta Arpio was a member of the legal service of the Council and also worked on institutional issues, and also member of the task force which prepared the Treaty of Nice and also involved in the Convention on the Future of Europe. I try to be very, very brief with your presentations, but I know you have more to say about your institutional experience, and this is why we are very happy and we invited you today to discuss together the topics at the core of our project. So thank you very much, all of you, for joining. I won't prolong the introduction, so now I would give the floor to the first speaker, Pervenche Perez.
Thank you very much. It's the privilege of the alphabetic order, I believe. Thank you to you. Thank you to the ULB, and I'm very proud to contribute modestly to a Horizon Europe project, because I think it's a critical program in the EU, and we definitely need it also to address the critical question you try to raise. Just want to make a disclosure. I'm not an academic, so I will not have an academic presentation, but I think this was the contract we have today. I will speak on behalf of my experience in the European Parliament, and thank you for the long presentation you made. But I have to add just two more points, since I was involved in two important projects related to what we will discuss right now after my mandate in the European Parliament. The first one is the Franco-German expert group on the future of Europe, where we immodestly have titled our report "Sailing on High Seas, Reforming and Enlarging the EU for the 21st Century." I'm sure you all know it by heart. It's a critical piece, I think. To my understanding, it's the only one on the table of this nature to think and work on the next mandate. And I've also was part of an expert group in the Commission settled by the DG, by Elisa Ferreira, on the future of the cohesion policy. And the report will be out, as you may know, tomorrow afternoon. And here also I will invite you to read it carefully, because it tries, this report on cohesion definitely was drafted having in mind the kind of question we have we will be discussing this afternoon. You raised three questions, and I will try to answer partly to all of them. The first one is, because of this dissensus, what is the capacity for the EU to act and regarding its external and internal policies. So this means I will not enter into the definition of the dissensus around liberal democracy, which might be the subject for another workshop you may have. My answer, as I said, my contribution, as I said, will not be an academic one, but it will definitely be based on my, in the way I have tried to fulfill my mandate, which is to understand that the answer to this question is definitely a mix between a political approach and an economic one. And this, for me, the bridge between the two is a critical one. Because when you discuss liberal democracy, you can have the idea that you are addressing an institutional question. But to my understanding, there's no institutional per se. And if you remember well, I was a member of the convention who drafted the constitution, as you rightly said. And as I'm sure most of you know, in the end, I said no to this constitution. Why? Because the policies that were going to be implemented following the adoption of this draft constitution would not be fit for purpose to address the challenge we were supposed to address. This has been a very, very controversial point also in my career, but I think this is, and when we started the work on this report, we also challenged the question, are the challenge the EU is facing going to be solved by institutional reform? And definitely the answer is it's part of it, but somehow the institutional setup is the contract people are ready to write down once they agree on the nature of the contract. And when it comes to the nature of the contract, here, this is where you have to discuss it. Because as I see the situation today, I see this question raising higher on the agenda. I mean, we are here today, 2 days after the death of Navalny. I think we all have a profound thought about it, not only for him, but for the Russian people and what it means for us. Because this is a more than a dissensus around liberal democracy. And what is behind is not a question of market, is not a question of liberal democracy or not. It's not a question of a member state attacking another one. It's much more than that. It's and many of the portrait of Putin when he attacked Ukraine referred to this, that he was going in a civilization war. And somehow we had forgot about it. And now with the death of Navalny, I think we are back to this point, which is it's not only our institutional setup that is challenged, it's our civilization. Which means, for me, that in the way we have been able, because of a compromise among 6, 12, 25, 28, 27 member states, to draw the line was around what is now our consensus. And our consensus merely was built on different layer, but the last one and the biggest one is the internal market, with its 6 accompanying policies, among which the currency, environment, social policy, cohesion policy, and others. And I think this was what we could do. But in the end, this is what is today challenge. I don't have time to go deep into all the detail, but I think this is the critical question we have to think about. Until I don't have the precise date in mind, but until recently, in the Parliament, you could see that there was a consensus working, mainly around the big compromise between EPP and SND. This one has been destroyed, at least since 2 mandates. So now you have another composition of the big compromise, which is challenged by this environment that I'm just describing. This means, to my understanding, what is at stake when we discuss rule of law, value of democracy, is of the essence. And I think the pure logic that we've been following, including in our enlargement, including in when we had the Troika working in Greece, for example, are things we need to revisit. When it comes to rule of law, in this report, I think it's one of the... We had a big discussion to find out where to put rule of law in this report. And in the end, we put it as the first item to be addressed. Just for one reason, the one I'm just describing, that it's a question of civilization. And our civilization is around democracy and rule of law, which means that the current setting, which was about, which is connected to the budget conditionality, is okay. It has demonstrated that it can be efficient, but for us, it doesn't address. There's two loopholes in here. First, it does affect people who could be our allies, because they are the one with whom we have to connect around our value and our sense of civilization. And second, the government somehow couldn't care less. I mean, I'm a bit blunt or over blunt on saying this, but it doesn't affect the reputation of the head of states and government that is conducting this policy. I know there will be around this table many arguments against the legal dimension on how to connect rule of law with Article 2 of the treaty, but we do believe in the report that this is the way ahead, having in mind that somehow we have two legal bases that have different use. Somehow the Charter of Fundamental Rights can be used or is used as a public definition of rule of law, while Article 2 is used by the Court of Justice. And I think your body language that my time is over?
1 minute more.
Okay. So in the end, I don't care if it's about the Charter or Article 2. I just have in mind this. And what we believe is that the Commission and the Council have been much too shy about using rule of law. And now I hope it's not too late, because we believe it's a critical point that we need to address. I think just one last point. If I look at what's going to happen in the next Parliament regarding the strategy of islands, as a French socialist, you might know that we were always opposed to this, how do we call it, technical agreement? No, there was another name, I can't remember. When we split the presidency of the European Parliament between the two big groups, technical...
Rotation.
Huh?
Rotation.
Yeah, but the rotation, it had I think it was a technical agreement, that whatever the majority in the parliament would be, there was an agreement. And for French people, this was really not in our practice, because we don't have the ambition. We have cohabitation sometimes, but we don't have the habit of big coalitions. So for us, it was always difficult to vote, for example, for an EPP president of the European Parliament. But now I think this situation will be even puzzled by the fact that some people are also thinking that in the future you could have an EPP ECR islands, which of course would reshuffle the whole equilibrium of what can be defined by the Parliament. I believe, I hope I will be able to contribute more in the debate, but this is in the disorder, the element I wanted to put on the table.
Thank you very much. I will now give the floor to Julio Baquero Cruz. Julio, please say 10 minutes.
First of all, I have to say I'm not speaking for the Commission. I am bound by the staff regulations to say that I speak here on a personal capacity, and that what I will say does not necessarily represent the Commission's position on these issues or the position of its legal service. So I will deal with the three questions together because I think they are aspects of the same, and I have a number of preliminary points. First, on the notion of permissive consensus, which I think it's too British for me, and I think it reflects this British dominance in European studies that has carried its negative bias for decades and has transformed almost the field and the very object of study. It's a peculiar understanding of the European Union, the British one, and it was not always correct or shared by other peoples in other member states, but it had a profound influence. And after Brexit, I think we need to rebuild a European way to study the European Union and forget about the British biases. Integration was never built on the basis of a permissive consensus, but I think on a real-willed, strong, democratic, overlapping consensus of the initial 6 states and their peoples around the basic structures of the project, conceived as a political, transformative project of the states themselves and of their interactions. This is very clear in the Schuman Declaration, also in the parliamentary debates about the ratification of the treaties of Paris and Rome, if you take the time to read them, but many people don't read them. When I say overlapping consensus, I refer to John Rawls, of course. He developed this notion in his book Political Liberalism that everybody should know, I think. In his theory, the overlapping consensus is just the minimum agreement over the basic constitutional traits of a polity that is required for its sustainability. It is not a comprehensive worldview like the one of Mr. Orban, for example. It can accommodate many such worldviews as long as they can be embraced with a reasonable measure of pluralism. In a liberal polity, you don't need to agree on everything. You just need to agree on these basic structures of institutions and values, which are the very foundations of the polity, and then in that framework you discuss policies. This is comparable to Bruce Ackerman's two-track politics. Bruce Ackerman famously differentiated between constitutional politics, which are not for every day, only for moments of heightened or difficult public life, and then normal politics, which take place every day. And we normally should agree on the framework of politics, the constitutional framework. In difficult times, times of instability, the frame itself becomes contested and up for discussion. Unfortunately, I think we seem to be in that position not only in the Union but on a global scale. For the Union, what are the basic foundations, the overlapping consensus? I don't think it's the internal market or any particular policy. It's the structures, and the following are essential. Article 2 with the founding values, the legitimacy of the institutional framework and of the community method with majoritarian decision making, and the Union's own rule of law with the Court of Justice, direct effect and primacy. These are the elements, structural, not policy, that are truly transformative and conform the essence of integration. Of course, they are also contested as they actually reflect the same values, democracy and the rule of law, that are being challenged by the liberals, but not only by them, also by other people. In the Union, I think more than a permissive consensus, what we had, I would say it happened around the mid-90s, around maybe early 90s, around the Maastricht Treaty, was a gradual erosion of the initial impetus and consensus around the idea of integration in a changed context with reconstructed states that no longer had a very strong interest in completing the project. In fact, EMU, with its serious shortcomings, or Article 7 TU, are clear examples of the weakening of the initial impulse. It was still there, but no longer with the integrity and solidity that it had before. This is also the context that revived nationalism and fostered Euroscepticism more in some states than others. After the Eastern enlargement, the crisis with the failure of ratification of the Constitutional Treaty, the entry into force of the Lisbon Treaty, which didn't really adapt the Union to the enlargement, and the following crisis, what we have is a constitutional mutation of the union system, in which the integration elements are framed more and more by a stronger intergovernmental layer. The union has continued to evolve, to do more, to be bigger, but no longer under the structures of integration as it was initially conceived. Integration was never completed, it was expanded but weakened at the same time. My second preliminary point is on this dissensus over liberal democracy. Is there one, really? How do you measure it? My impression is the following. It's true that liberal, or rather constitutional democracy, can no longer be taken for granted. It is under attack and challenge in Europe and beyond. But at least in Europe, my impression is that in the large majority of member states, the large majority of political forces still remain loyal to constitutional democracy, and that dissensus is constrained to the extremes of the political landscape in the large majority of member states. Of course, these extremes are growing, and for how long will they be a minority? Is this tendency going to grow forever? Is there a limit to it? I think we will see the result of the next European elections and national elections, and this will be a test. Having said that, my response to your questions will be extremely simple. First, the main constraint over the Union's capacity to act is not related to increasing dissensus over liberal democracy. It's rather the other way around. The Union's own intergovernmental drift since the Treaty of Lisbon has constrained its capacity to act, especially in certain fields, multiplying the veto positions, reducing action to the common minimum denominator, or blocking it altogether. Second point, the intergovernmental responses to the debt crisis and to other crises, migration, what have you, may actually be one of the central causes of the dissensus over liberal democracy. Why? Because those responses contributed to create in many member states problematic socioeconomic conditions that have been feeding those ideologies. Third, the intergovernmental mutation of the Union as a polity has also for over a decade hampered the Union's capacity to react to illiberal tendencies among its member states. How has the Union responded to this situation that was in part created by itself, by its own mutation and difficulties? How do the institutions deal with it? We see the Union trying to go back to a more sensible and rational mode of action to recover some capacity to act. After being stuck for so long, for example, with the useless procedures under Article 70 EU, which everybody knows is useless, it has developed some instruments that use the community method, that had been created by the community method and use the community method to tackle some of the rule of law problems, which are one of the main symptoms, although not the only one, of illiberal regimes in the context of its various policies linked to the budget, the economic conditionality. Some would like to see more, but we don't know yet how effective, these new instruments will be, but they seem to work much better than anything we had before. In other fields such as taxation, international sanctions, or defense, the Union's capacity to act remains constrained and thwarted. This is therefore a constitutional issue that goes well beyond the dissensus over liberal democracy. At bottom, it's about whether integration will or will not be completed according to its original DNA, the only one that can work and make sense, completing the Union as a post-sovereign policy, or whether the Union will be dissolved in the intergovernmental mutation that leads to an association of sovereign nations with heightened state control over the Union, while choking at the same time its capacity to act and creating the conditions for its implosion or dissolution, as you prefer. You cannot have both things at the same time. The founders of the community knew this very well, but we seem to have forgotten it. So the Union's capacity to defend and maintain its model of society, the European society, and the values on which it's based depend on this one issue. And I think it will boil down to its ability or inability to reform and improve its constitutional structures. Again, I will be quite short, and this is my final point. Either the treaties are reformed, even between only a group of willing member states, to render constitutional change more flexible, generalize the community method, and improve the democratic life of the Union and its channels of representation, or we risk the implosion of the system, which would become unable to support so much political pressure. I am quite pessimistic on the capacity of the current political classes and the electorates to fully grasp the extent of this challenge for European society. And I wonder how bad does it have to get for them to realize what's at stake. Thank you.
Thank you very much. Thank you, Julio. Martin, I give the floor to you. I will hear from the point of view of the court or from any point of view.
Not really. Well, almost I will. First of all, thank you very much, Ramona, for the invitation and for describing me as a friend of the Institute, which I certainly am. I'm very honored to be here with you today. And second, I need to start with a disclaimer similar to the one of Julio, which is that obviously I am not speaking on behalf of the court. These comments are purely personal, but I do intend to talk about the work of the court, but this is just my personal view. The first preliminary remark with which I would like to start is that although we haven't got into the details of that, is that unlike with the other institutions, the court has obviously a reactive role. It doesn't have a proactive role. In other words, the court cannot choose the litigation that is brought before it. This seems perhaps an obvious remark, and it is, but I think it's important as well to understand the issue that brings us here today. The court can, however, influence the type of cases that are brought before it in two ways. One, with admissibility decisions. That is, if the court decides that a certain type of action is admissible, this in turn may provide an incentive for future applicants to bring similar types of cases. And conversely, if the response is that those cases are inadmissible. And secondly, it can also adopt substantive decisions that may or may not incentivize applicants to bring similar types of claims. For instance, if the court concludes that a certain type of claim is well-founded, someone else may in the future decide to bring a similar case. Those considerations typically apply to direct actions for annulment, actions for failure to act, even damages actions or infringement proceedings. But in a way, these considerations can also be transposed to the so-called indirect actions, that is, the preliminary references. And in particular, if the court decides to engage substantively in the context of a preliminary reference with a type of problem raised by a national court, then other national courts may seize that opportunity and do so in the future again and again. And I think these two elements serve to explain what has happened in this area from the point of view of the court. Now, I think internally, if there is any sort of dissensus over liberal democracy in Europe, I don't think that has had any impact on the court's ability to act. And I say, if there is, I'm not saying that there is internal dissensus over liberal democracy in Europe, but assuming that there were, because the court acts by simple majority, the decisions are taken internally by simple majority, those elements who might perhaps be characterized as dissenting elements do not have the ability to block or prevent the action of the court. And I think the track record of the court, that is, its case law, clearly shows that has been the case. That is, that there has been no blockage on the functioning of the court in relation to this issue, if I may say, with all due respect, unlike what we have seen in relation to other institutions. So, in my view, the very important role that the court has played in this area results from two different factors. One, at EU level, what I just said, the difficulties of most of the other institutions to act in this area in relation to this dissensus over liberal democracy. In fact, the court has become perhaps the main avenue or the main hope for those willing to do something about this for a long time. And the second factor is as well that at national level, even in those countries where there has been this dissensus over liberal democracy, that has led also to some resistance, internal resistance, and those actors dissatisfied with the evolution of the course of events have seized the opportunity to seek assistance from the court, to bring cases, to litigate, and then, in the context of the preliminary references, try and bring those issues before the Court of Justice. So, how has the court dealt with the census over liberal democracy? Well, essentially, the court has tackled this from the angle of the rule of law, which it is in the Treaty of the European Union, Article 2, since Lisbon, but also is part of our acquis communautaire since this famous case, Lever, against the European Parliament, where the court said the Union is based on the rule of law, and that no one is above the rule of law, neither the institutions nor the member states. And the court has essentially used three types of provisions to deal with these problems. Article 2, I just mentioned that. Article 19 of the Treaty on the European Union, which is a provision that says that the court will ensure the respect of EU law. It is the guarantor of the interpretation and application of EU law in the Union, and that member states shall provide sufficient remedies, effective legal remedies, plus Article 47 of the Charter, which also establishes the right to an effective judicial remedy. So these three provisions, Article 2, 19, and 47, are decisive, fundamental in this area. The big case concerning the rule of law in Europe that was brought before the court had actually nothing to do with the census over liberal democracy. It was the famous case on the Portuguese judges, where some judges, some people consider that a temporary reduction of the salary of the members of the Cour de Comptes, Court of Auditors in Portugal, was an attack on the independence of the judiciary. And as you see, this has nothing to do with this census over liberal democracy, but the court relied on these three provisions and explained that the EU is based on common values that underpin the essence or the basic premise, which is that of mutual trust among member states. Member states have decided to adhere to these common values voluntarily, and that is essential for this mutual trust to function. And then it reminded the obligation to provide effective remedies, Article 19 and 47, and explained something very important as well, is that there is a shared responsibility between the Court of Justice and the national courts in the context of the preliminary reference to ensure the respect of EU law, also assisted by this duty of loyal cooperation. So these three elements, common values, effective judicial remedies, and the symbiotic relationship between national courts and the Court of Justice, the complementary relationship between the national courts and the Court of Justice, thanks to the preliminary reference mechanism, is what allowed the court to open the door to examine in the future these type of cases. Now, the Commission took note, and also national courts took note of that judgment, and very shortly afterwards, this was a judgment of 2018, very shortly afterwards, the Commission brought two immediately afterwards, and a little bit later another one, infringement proceedings against Poland. The Commission understood that actually that was the opportunity to use the legal provisions in the treaty to deal with this problem, thanks to or with the assistance of the court. And we had the famous judgment on the independence of the Supreme Court. As you know, there was a change in the legislation that allowed, that in fact reduced the compulsory retirement age of judges of the Judicial Court, of the Supreme Court, subject to the possibility for the President of Poland, discretionary, to maintain them after they had reached a retirement age. I will not bore you with the details, but a litany of cases, this one plus another one concerning ordinary judges, plus another one concerning the disciplinary chamber applicable to ordinary judges, allow the court, on the basis of these three provisions that I mentioned, to try and assist those resisting the drift towards illiberal democracy in some member states, well, to challenge that drift. And as I said, the Commission took note of that opening, of that door that was opening, but also national courts. And only in the span of 5 years, we have had over 30 preliminary references from national courts seeking assistance from the court concerning issues in Poland, in Hungary, in Romania, and also in Malta. And the issues analyzed are quite diverse, but generally speaking, fall within the following categories: the structural independence of the judiciary and the impartiality of judges, the irremovability of judges, the appointment of judges, and disciplinary proceedings against judgments. The last type of procedural avenue used before the court to deal with these issues is a direct action brought by Poland and Hungary against the conditionality regulation that Julio knows much better than I do, so I will leave him discuss this later on. But as you can see, and I conclude with this, I think the obvious and unavoidable consequence of what I just explained is that the court has not experienced any particular difficulties in dealing with this type of cases concerning the dissensus over liberal democracies. The court has issued numerous judgments, and very bold judgments, concerning these problems. Some of them initiated by the Commission, most of them initiated by national courts. The second point that I make is that the court does not seek to impose uniform requirements, of course, regarding the rule of law in member states. Only minimum requirements. It's like some sort of safety net, which is perhaps complemented by the so-called standstill clause that the court identified in another judgment, Republica, Maltese judgment, where it said that in fact there is no regression possible in the protection of the rule of law. You can only increase the protection of the rule of law. You can never go back. You can never reduce that protection. The third remark is that I think it's clear, and one has to acknowledge that there is a tension between establishing these minimum requirements by means of Article 2, 19, the Charter of Fundamental Rights, etc., and the respect of the national identity of member states resulting from their constitutional traditions, Article 4.2 of the Treaty of the European Union. There is a tension, clearly, but that tension, even though it requires a difficult balancing exercise, has so far been resolved by the court, weighing on the side of these minimum requirements concerning the rule of law. In fact, to put it differently, that argument has been rejected by the court, in particular in the case concerning the conditionality regulation. And finally, the final point would be on my part that even if I believe honestly that the role of the court has been absolutely decisive in this area, particularly when nobody else was capable of doing something very fundamental, very radical, at the end of the day, the approach has to be by necessity on a case-by-case basis. So the case law and the action of the court cannot solve the problem by itself. It's just impossible. The court will analyze the cases that are brought before it, and to some extent, for a long time, it has been perhaps the best solution we have had, but this cannot be the silver bullet. The political actors, those who have their proactive role in their hands, they will have to do something to solve this once and for all. Thank you.
Thank you very much, Martin. Thank you. My voice is reading. I hope you still hear me. I give now the floor to Jakob Oivan. Please share with us the perspective that you have from the COSAC. You're a COSAC speaker.
Thank you very much, and first of all, thank you for having me here in this very august panel. It's particularly fun, I would say, for me because Madame Perez is here, who without whom I wouldn't be here, you could say, because without her there would be no COSAC. And I should also just wanted to make a brief remark. I've been listening with great interest to all three of you, and quite different but very, very interesting points of departure. I will perhaps bring this down a little bit more to the ground with speaking of the interparliamentary, as we call it, perspective of COSAC, my starting point is the role of national parliaments within the EU architecture and the role that they can play kind of institutionally. Of course, this cooperation also includes the European Parliament, but I will focus a little bit more on national parliaments, which is what I know perhaps best also. My background is as a representative for the Swedish Parliament before I picked up this position in January. And I think, of course, national parliaments are a natural object of interest when speaking of dissensus of any kind, because that's what they are for. They are there to channel dissensus. But I think perhaps also a little bit similar to or even more so than the Court of Justice, national parliaments tend to be, as institutions, very reactive. They don't have very strong agency. And so this colors, of course, their ability to act as institutions and to act together also. Somebody once said that cooperation between national parliaments is like herding cats. It's slow and it's difficult, but it's there, and it's also quite interesting that I think in Europe we have this quite far-reaching cooperation between national parliaments within the EU architecture. But of course now national parliaments are a natural arena for dissensus. But I take it this discussion we're having here is more on, is there a challenge to the basic precept, the basic rules of the game we're playing here? And then it's another question, of course. Then it's not so much of what we should do, but of how we are doing it, the basic fundamentals of democracy, and that puts parliaments in a more difficult situation, I would say. But my main message, I think, today would be that stronger parliamentary engagement within the EU and with EU matters could help to take a little bit the edge of such a development. At the same time, I strongly agree with Madame Beresh that started with saying that fundamentally I believe this is a political issue. There has to be a political will, and as institutions do matter, but the institutional setup of parliaments within the EU can only do so much. But having said that, let me just briefly describe to you the role national parliaments play, because I don't think it's super well known within the EU, and what role they could perhaps play to a little bit smoothen out some of the creases here. I think also I should say that I think the national parliament's engagement with EU matters is underappreciated, but it's also not very much studied academically, and it is also underutilized by the national parliaments themselves. So for these reasons, they also tend to punch a little bit below their weight. And there are, just briefly, two main forms of engagement for national parliaments with the EU. The first one, where I'm engaged right now, is with interparliamentary cooperation, where national parliaments, together with the European Parliament, meet regularly in different constellation to discuss topical issues and have an exchange of best practices. And the other leg is scrutiny of their own governments mainly, and their action in the Council, but to a certain and limited degree also directly scrutiny of the EU institutions, perhaps most famously through the subsidiarity instrument, whereby national parliaments have the opinion to voice their concerns on new legislation. But if we start with the first one, I think it is interesting to note that the COSAC was formed in 1989 and was for quite a long time the only real forum where national parliamentarians and members of the European Parliament could meet and discuss current political issues. And this was like this for some time, but that today this tendency has grown, and today we have a large scope of such forums, and at least 5 institutionalized interparliamentary conferences, plus other ones. And I think that they play an important role in involving key players in each national parliament. In the case of COSAC, the EU affairs committees that have a central role in formulating the national policy towards the EU and bridging a little bit also the famous democratic deficit, perhaps, of the EU. I would say that the problem here is that a little bit they exist in a vacuum, and they could be utilized more as a very good sounding board, really, for picking up signals early on changes or challenges to dissensus on basic issues, for challenging early on a plurality of views, which is the strength, again, of national parliaments. The other tool that I mentioned, of course, is the scrutiny. And here most parliaments have some sort of mechanism for controlling their government and their behavior in the council. And they thereby provide a kind of a link, an anchor, I would say, for linking national debates and concern with the development on an EU level, as well as, of course, exercising a kind of basic principle of democratic national control and providing legitimacy to the decision-making on the EU level. So I would say if one source of a growing dissensus, or one reason one could challenge easily on a national level the action on the EU level for political actors would be that there is a perceived disconnect between a national level and the EU level. The so-called Brussels bubble, whatever. And I mean, we are all aware of the problem that on a national level, what happens in the EU is kind of talking about on a broad level, is often described in a way that is not really right. Also, Brussels is blamed for problems, and successes are kind of taken. The national governments take credit for them. I think that one way to bridge this disconnect, and again, I'm not talking about something that will perhaps change the fundamentals, but something that could take the edge of these problems a little bit, is offered through national parliaments. And that's the way, I mean, that by using this bridge, this kind of blow of the force of this tendency towards a growing dissensus could be lessened. This may seem a bit abstract, but I could also give concrete examples of this working in practice. For example, the experience of COSAC gives EU affairs committees a more clear view of the kind of lie of the land of the debate on issues in the EU. And my experience also is that it gives them a more humble approach to the possibilities and difficulties inherent in EU decision-making and in negotiations. So, just to sum up, my point here today would be that stronger national parliaments within the EU architecture would mean that difficult and dissential issues would be challenged earlier and more clearly, which could give room for finding solutions to these discrepancies earlier on in time. And stronger national parliaments would mean more involvement from national level, and involvement more often than not leads to a stronger sense of ownership and engagement. And with a sense of ownership and engagement, often at least comes a more constructive approach. And, well, I would think I will stop there with that as my main
Thank you.
last point. Thank you.
Thank you very much. We will discuss more in the Q&A session. Please, Martha Archio, you have the floor for 10 minutes.
Thank you very much. First of all, I would like to thank Professor Corman and the Institute for European Affairs for the invitation. It's a pleasure to be here. I have the same disclaimer as Julio and Martin. I speak here not a representative of the Council, but in a personal position. But of course, what I will tell you is based on my long experience now as member of the Secretariat of the Council, but I was also in the Secretariat of two conventions, in the Convention of the Future of Europe, and also the convention that drafted the Charter of Fundamental Rights, not as member, but as in the Secretariat. And also I have been in 3 IGCs, Amsterdam, Nice, and Lisbon. And last, I was also co-head of the Secretariat of the Conference on the Future of Europe. And now, as you see, Future of Europe is one of my specialities. I don't know if it's a good thing or a bad thing, but now I am in charge of the preparation of the Union for a possible future enlargement. That's my new file, Future of Europe, also in my title at least. Okay, exactly. No, I was in the Council when you presented, when you two colleagues presented the report. I am following it very, very closely. And then I will try to on the basis of what has been done and what is being done now, I will try to answer to the different questions. Of course, dissensus over liberal democracies has an effect in the European Union and in the institutions. And I would say that in particular on 3 institutions, because we have 3 institutions that are the result of elections, more democratic elections. That is the European Parliament, democratically directly elected, and also we have the European Council and the Council, which members also come from elections, from democratic elections, and they are under the control of the national parliaments. And then, of course, when there is dissenting democracies in one of these governments, and then, of course, it has effect in the capacity of act of the institutions. Why? Because it's more difficult sometimes to reach agreements, because if there is no consensus about some values that are very found the European Union, sometimes in particular on some policies also, you know that the dissenting democracies and then don't have sometimes the same values. And then, of course, there is an effect in the institutions, in particular European Council and European Parliament. The Court of Justice, I think, is more, as you say, more outside all these political and it should be like this, of course. And then, but I would like also, after having said this, I would like to remember also 2 things that for me are important. First of all, European Union, as Julio remember, the community method that we have heard for a long time, is the European Union is a sui generis construction that is based on a system of checks and balance. It means that we cannot compare exactly the effects of the illiberal democracies in the European Union in the same way as in the national member states. Why? Because in the European Union we have to remember that we have several institutions that converge in the different processes. For example, legislative process. The legislative process, now European Parliament and the Council, we are co-legislators in more. And then the Commission represented the common good, common interest, has the right of initiative. It means that when we decide in the different fields, there are several institutions together that need to converge or needs to find agreements, because consensus, compromises is at the heart of all the process. First of all, in the Council, we need compromises between the members. After, we need compromise with the European Parliament through the legislative procedure. And then this compromise process, I think, makes more difficult the influence of by political changes in the European Union than in the national democracies. I think in the European Union, this this system of check and balance, I think, makes the influence a little bit less direct, if you want. And the second thing I would like, and if you follow a little bit, I am sure you do, the practice of what is going on in European Council and in the Council, sometimes it's very tough. Sometimes we need long negotiations, long compromises, but at the end, we find compromises. It means sometimes not. I am not saying that always we find, but if you take the example of the last European Council, that it was really, we didn't reach a compromise in December, but at the end of January, there was a compromise. Okay, they were tough negotiations. You can, but it means that sometimes member states don't like to be isolated, even then, and political pressure or negotiations can facilitate sometimes to reach a compromise between all the members, I say European Council and Council. That's why I would like to relativize a little bit. For me, there are in the way the European Council and the Council work. They are my institutions for which I work, and then I think that finally this compromise culture works in most of the time. Not always. Not always. I am not saying that, but I think we have examples in the past really where we have been able to. How the European Union institutions have responded over the past. I think for me, to this increased dissensus. For me, I would like, and some of my colleagues have already mentioned, I think one thing very, very important during the last years since the Amsterdam Treaty is that the European Union, little by little, has reinforced the rule of law and the democracy as the founding values of the European Union. These values have existed since the beginning. It's not new, but I think little by little they have really improved the mechanism to protect these values. I am not saying that these mechanisms have already worked. That is another issue. Okay, but I think if you see, for example, and how they have reinforced this. Rule of law and democracy values. I would start, my first point would be to remember that the European Union membership is based on the values of democracy and rule of law. And I think that is important to recall this, because it was in 1993 when the European Council in Copenhagen that established the different criteria for the accession of new member states, put it very clearly that it was a condition to be member of the European Union, to have institutions that guarantee democracy and rule of law. After the Lisbon Treaty made this more explicit, because the Article 49 now, if you read the Article 49 of the treaty, is very clear that democracy and not only democracy and rule of law, all the values that are recognized in the Article 2 of the European Union Treaty need to be fulfilled by the candidate countries in order to be member of the European Union. And I think it means that now the European Union membership is directly linked to democracy and rule of law, and the candidate countries have to introduce the necessary constitutional, judiciary and legislative adaptation before entry. And I think it's a very important element because it's a leverage for improving the democracy and the rule of law in European Union. Of course, we have also other mechanism to protect the rule of law that applies not to the candidate countries but to the members already, members of the European Union. I will not go into detail because my colleagues have already mentioned some of them, but of course it's the famous Article 7 that you can say has worked, has not worked. It's true that Article 7 is a very complex and very political mechanism, and then that implies an initiative from Parliament, from Commission, from Member States, and after needs 4, 5, 5th in the Council, and it's not very easy to but it's there. And now the Lisbon Treaty reinforced this mechanism because it was created by the Amsterdam Treaty, but after with the Lisbon Treaty, this mechanism was enlarged not only to breaches of the fundamental values of the European Union, but to the risk of breaches. It means that now this article has a preventive function in addition. We have also the conditionality regulation that has already been opened against some member states. And we have also the infringement procedure that is the Commission and the Court of Justice that are in charge of applying this. But now the fact that now in Article 2 that we have now a very explicit provision that really mentions all the different values on which the European Union is founded opens the way or facilitates to open infringement procedures against member states that violate these values. I am not going to judge the application or not application because maybe my colleagues would like to add something on this, but I am just saying what has been done by the institutions and in particular Council and the IGCs and Convention, because a part of all this mechanism come from the Convention on the Future of Europe, where even national parliaments were associated. I would... Sorry?
No, I'm just saying that the European Parliament was not associated. It hadn't driving. It was in a driving seat to launch the whole process about Article 7.
Well, no, the initiator can be Parliament, can be member states, can be Commission. Three.
But in reality, the political will has been.
Okay. Yeah. And I would like to mention also another mechanism that we have developed in the last year, because I was also participating, is the issue of the participatory democracy. And I think that we could consider this also as a mechanism a little bit to go beyond a little bit the national illiberal democracies when does it exist. I am not saying that this mechanism is for this, but it can be. Why? Because the Conference on the Future of Europe, that was the first exercise at European Union level of participatory democracy, it was really a quite innovative mechanism, because if you realize it was the first time when citizens were in direct contact with the institutions of the European Union without the national governments. And then this exercise that, the outcome was this final report of the conference that now is being implemented by the institutions, and then established by the first time a direct link between the citizens and the institutions. Now the Commission continues with this participatory democracy, and then now the Commission has organized panels with citizens before some legislative initiatives. How now, currently, and I would like maybe, because I don't have many time, and then I was going to mention some elements of the defense of the democracy package that the Commission has presented. Just one element of this that I think is important in this way is this recommendation of the Commission on inclusive and resilient electoral processes, and I think it's really the idea of this recommendation is that to improve a little bit the resilience and the how do you see the transparency and the respect of standards in the different national processes, and also of course in European Union elections. And there is another recommendation of promoting the participation of citizens that is a follow-up of the Conference on the Future of Europe. And then maybe this open ways. Last thing I wanted to say you, because there are all other initiatives, but I am not going to then. But I wanted just to mention a little bit, because now in the work of preparation of the Union for the next enlargement, you know that there is a criteria of this Copenhagen criteria that needs to be fulfilled in order to enlarge the Union. One is for the Union itself, and it means that we need to be able to continue to develop even after the enlargement. That's what we call absorption capacity. And then in the framework of the examination that the Swedish presidency already started, and then now we are continuing to, we need to examine 3 blocks of issues: policies, budget, and governance. And then on policies, I can tell you that the policy that will be examined in the first time, in the first rank, it will be the rule of law, because everybody agrees that rule of law is a pillar of the European Union, and then we need to examine if the rule of law mechanism are adapted for an enlarged union. And then this examination that has not started yet, because we are really in the first part of the work, of course, opens a way really to improvements or to explore maybe new ways to protect the democracy and the rule of law in the future, because not only because it's one of the pillars of the union, but as I think Martin said, also mutual trust is fundamental, or also rule of law is a prerequisite for the mutual trust that we need, is fundamental in some policies of the European Union, as in the area of freedom, security and justice. And I think my time is finished. I will not continue, but I have other things to say, but maybe in the debate I can tell them.
Well, thank you very, very much for the 5 points of views and the presentation.